Manever I say ma PENDREAM TV. PENDREAM TV there, I see them yopo.
It's your challenge with what appears to be from your submission a case of selective justice, or you still think that based on everything that you've heard and everything you've read from the documents, you still think that Wontumi?
I'm surprised you even.
Wontumi did no wrong.
No, I'm surprised you even asking me whether it's a case of selective justice.
Right.
Is it not clear to everybody? The president himself is saying that his people are involved in Galamsey. Nobody has been prosecuted.
Okay.
The Attorney General himself told us that he has referred key members of the party to Yoko. A year ago, the same time Wontumi's case started. We've not heard anything from them. So it's not about me saying it. It's palpable. It's clear for everybody to see how selective it is.
I get it. My question is your concern the matter of selective justice, or your concern has to do with the basis upon which Wontumi was incarcerated? Which is more important to you? Both?
Yes.
Okay, so you disagree with the reasons that the court gave?
Absolutely. The party has come out clearly with our
all right, I just need some. But
of course, we can disagree with the courts.
Yeah, that's not.
If you have the right to disagree with the courts. Yes, and that is why we are going to an appeal.
Okay.
Any appeal is a critique of the previous judgment.
Okay.
And so that point must be made.
All right. Kwesi, I've sought my clarity. Please come in.
Okay. I mean, like colleagues, I suspect that I have a right to describe Wontumi as a friend. I recall that more than 25 years ago, a gentleman called Atik Mohammed brought Wontumi to my office. I was then working in the inside.
I mean, PNC's Atik Mohammed?
Yes.
Okay.
He brought Wontumi to my office.
Okay.
He was going through some problems and so on. And indeed, Wontumi was in my office 2 or 3 times a week over a long period of time. And that was long before he became regional chairman of the New Patriotic Party. And I've met him a few times. The last time was about 3 months ago when I went to eat somewhere and he showed up. And he was very, very confident that he was not going to go to jail. And I wouldn't state the reasons he gave because that may be prejudicial. So I wouldn't state the reasons he gave why he was so confident that he was not going to go to jail. So he's my friend. Okay.
It won't be prejudicial anymore, Kwesi, because the judgment is out now.
Pardon?
The judgment is out
appeal
now.
Process.
No, it hasn't been appealed yet.
I know what I don't want to say.
Okay, that's fine.
I know what I don't want to say.
I understand.
What he told me.
I take him.
And he told me that in the presence of 3-4 other friends. You understand? So I wouldn't say that now.
Right.
I would presume that what he told me was in confidence.
That's true.
And I'll keep the confidence. However, I think that, look, we must approach this case from the position of law. Okay? This case must be approached from the position of law. And the law is that any person against whom charges are brought against should be given every opportunity to defend themselves. They have a right to remain silent. They have a right to engage lawyers of their choice and so on. Nobody has made that case that he was not given an opportunity to defend himself. Nobody has raised that issue. He chose his own lawyers. He had a right to remain silent and so on. All of those were observed. Now, the position of the law is also that if you're convicted by a competent court and you have reservations about the judgment or you think that the judgment was not proper and so on, there are processes of appeal. So you can go to the Court of Appeal, for the decision and argue that the decision should be reversed. And to that extent, there's absolutely nothing wrong with the decision of his lawyers and party lawyers who want to go to the Court of Appeal. That is the position of the law. There's nothing wrong with that. Now, even if the Court of Appeal should make a ruling or should make a determination which they still find unacceptable, they can still then move on to the Supreme Court. And even when the Supreme Court has made a decision, they can go for a review.
Yeah.
This is the position of the law.
Right.
So I cannot, in fairness, be arguing about the decision or the intention to go to the Court of Appeal. That is proper, that is right. It is the right of Wontumi to go to the Court of Appeal, and nobody can contest that. My problem is this, and my brother Collins had said so, that the case is a political case because he happens to be chairman of the New Patriotic Party in the Ashanti region. That's problematic. You understand? That is to suggest that a chairman of a party in the party stronghold cannot commit a crime. And that if he commits a crime and he's tried, it becomes a political case. That's a huge problem.
Well, not necessarily. Okay.
Explain to me.
If you say that he cannot commit a crime, I don't think that's what he suggested. He just meant that it's such a big blow to the party because this is a guy who chairs the party in their stronghold.
It doesn't make the case a political case.
He may have to explain why he thinks it's a political case. He may have to come back and explain that.
The fact of his being chairman of the New Patriotic Party in the Ashanti region, which is the stronghold of the party, does not make the case a political case.
Okay, that's a fair point.
That's the point I'm making. Now, the other ingredient, which my brother and friend, and Collins, I'm entitled to call you a brother and friend, I suppose.
I'm humbled.
Yes, sir.
Yes.
The other point he makes is that, look, who prosecuted him? It's the Attorney General who prosecuted him. The Attorney General is a member of government. In fact, he sits in cabinet. And therefore, this is a political case. That's a huge problem. Okay. Now, we have made reference to these provisions of the Constitution over and over and over again. And I'm going to do so again today. This is the 1992 Constitution.
Okay.
In the 1992 Constitution, Chapter 88, Clause 1 says, "There shall be an Attorney General of Ghana who shall be a Minister of State and the principal legal advisor to government. The Attorney General shall discharge such other duties of a legal nature as may be referred or assigned to him by the President or imposed on him by this Constitution or any other law. The Attorney General shall be responsible for the initiation and conduct of all prosecutions of criminal offenses." This is the Constitution. So if you make the argument that the fact that the Attorney General is a member of government, the cases he prosecutes become political cases, there's a huge problem. So by extension of logic, you'll be saying that the prosecution of Atai was a political case. So any case prosecuted by the Attorney General, by extension of logic, becomes a political case, in which case there can be no prosecutions in Ghana. That's a huge problem. Okay. Now, the other thing that I like to touch on is that we are always, anxious, and maybe legitimately so, to defend the rights and reputations of persons who are prosecuted or who, the judiciary has to make decisions on and so on. That's fair. I'm not worried about that. But in the process, we deliberately attack the integrity and reputation of persons who sit on the bench without justification. Because to say that this case was not judged on its merit and that it was a political case and that Chairman Wontumi is a political prisoner is to attack the integrity of the judge without foundation, without basis. You're saying that the High Court judge did not consider law, that the High Court judge was influenced politically in order to come to this conclusion. This is most unfair.
Have you heard about the ethnic considerations too? I don't want to repeat what the person put out on social media, and it became very topical.
I don't think we should even
Yes,
raise
yes,
that.
I get
It's
it.
so nauseating.
Yeah.
It's sickening. You understand?
Yeah.
So nauseating and sickening. Horrible. Should not be permitted.
Yeah.
And especially when that is done by political leaders.
Yeah.
You understand? And come to think of it, this lady who sat on this case, from what I've learned so far, was appointed by the previous government. You understand? And I think that it would have been wrong if, for example, she had set Wontumi free and said that the case had no merit. To go to the root of who appointed her to make a determination as to whether the case was political or not.
Yeah.
Let's be fair to our judges. We are so unfair. For our own narrow political interest, we will destroy anybody's reputation. The same way you want to defend the rights of Wontumi, the same concerns, the same principles should guide you in the defense of the rights and reputation of those who sit on the bench. That's just being fair.
Absolutely.
It's just being fair. You cannot roast people who are on the bench just because they happen to carry out their professional duty and you don't like their style or you don't like their conclusions. That's most unfair to the bench. You understand? And I'm not happy with the way in which things are moving. Yes, there may be legal points, legal basis for appeal. Emphasize the legal basis for appeal. Go to the Court of Appeal and get a judgment and stop destroying a judge who, for all intents and purposes, may be innocent. You understand? We are not bound to agree with decisions of all the judges. Indeed, we have a right to criticize decisions of judges and so on. But to recklessly and without foundation seek to destroy their reputation and so on, it's unacceptable. Clearly unacceptable. And I insist on that. Now, one of the issues which has been raised, and this is a purely legal issue, and I discussed this person in all honesty as a layman, okay? I'm not a lawyer, but it's an issue which has been raised. And I'm entitled as a layman to discuss these matters because these are matters which affect all of us and so on. The point has been made that accused persons are not under obligation to, as it were, even speak during their trials. They can remain silent. They can refuse to answer questions and so on. Okay. So the proof of the offense must be established by the prosecution. The accused person has no obligation to prove his innocence.
That burden is not on them.
The burden is not on the accused person.
Yeah.
Okay. Now, in this judgment, which I've read very carefully, and this morning I was asking for a copy, which you haven't given me, so I could do the
We'll do that.
properly.
It's on his way, sorry.
But Moro,
Yes, sir.
part of the judgment
Yes.
says that certain things were alleged against Wontumi,
Right.
and that in cross-examination, Wontumi did not respond to that.
Yes.
They were not challenged. And therefore, the court assumes that they are true.
Right.
That's a problem. That's a proper problem with the judgment. Okay? Because by extension, the argument the court is making is that because he did not challenge those assertions,
Yes.
especially during cross-examination, they must be held as valid.
Yes.
That imposes the burden on the accused person rather than on the prosecution.
Yes.
And I find this problematic. But this is a matter which will be pronounced on by the Court of Appeal. And maybe eventually even by the Supreme Court.
Right.
And this is a matter that dependent on what the Supreme Court and so on come to, may inure to the benefit of Chairman Wontumi.
Right.
Now, the other argument I've heard, and it's a very interesting argument, is that, Chairman Wontumi was not involved in Galamsey.
Yes.
That's the argument which has been made.
Yes.
He was not charged for directly being involved in Galamsey.
True.
That was not the charge. The charge was that he had been given a concession and that he illegally, without appropriate authority, allowed another
third party
to mine in the concession.
Yes.
So the fact that he personally was not involved is neither here nor there. You understand?
But obviously, before you go ahead to talk about whether it's neither here nor there, but you should also understand those who are seeking to set the record straight on that, because a certain impression is being made that Chairman Wontumi himself was on the field doing Galamsey. You know how sometimes we like to spin things, and that's why those who are correcting that are doing that. But yes, it's a fair point you've also made. You know, there was a certain narrative some people were trying to spin and to make it look as if he himself, as saying Chairman Wontumi, was on the field mining and doing Galamsey, and that's why Collins had to set the record straight on that.
The court didn't say that.
Yes, I know.
The court is clear. The court didn't say that.
I know.
And that was not the charge which had been brought against him.
It was actually a response to spinning doctors. Those who were spinning it and making it look like not what is here.
Are we going to base our decisions on social media things and so on? Obviously, that's not where we want to go.
Right.
When you are discussing such an important matter.
Right.
But you see, the judge herself averted herself to this question of the duty of an accused person and the duty of the prosecution in proving facts. And she referred to Justice Kosa, who was then Chief Justice, in a ruling, a judgment which had been given. And she says, this is the judge who sat on the Wontumi case. She says, the law is well settled that there's no burden on the accused. She makes the point. If there's any burden at all on the accused, it is not to prove anything, but to raise a reasonable doubt. If the accused can raise only such a reasonable doubt, he must be acquitted. This is the judge who sat on the case. So it's not like she was not mindful of the fact that the accused person has no obligation to prove anything.
Yeah.
You know, she was mindful of that, and yet she came to this conclusion. In fact, she also deals with a certain matter which is very, very important, and that has to do actually with, I'll come to that later. She deals with a certain matter which is very, very, very important, you know. I'll come to that if I had it earlier, I would have marked those portions, but I'll come to that much later, you know. Let me make the other points. Now, the other point that I like to make has been repeated several times by my brother Collins, you know, Honorable Member of Parliament and so on. And which is this point of unfairness, you know, selective justice and so on. Now, what is the basis of that selective justice? The basis of that selective justice is that, why? There are so many people involved in Galamsey who are not being prosecuted, presumably because they are members of the NDC. That's the case that Collins and others have made. Now, where is the evidence? They have mentioned two persons who were accused of Galamsey, and the matter was referred by the Attorney General to the Economic and Organized Crime Unit for investigation. And according to them, for 1 year, we haven't seen the report of the investigations. Fine. I haven't seen the report of the investigation. But what are the things which are probable? What are the probabilities? One, that the investigation has not been concluded. Two, that the investigation has been concluded, but the report is being shelved. That the report, which may be incriminating, is being shelved. Three, that the report has been received and there's nothing incriminating in the report. There may be other possibilities, maybe 10 other possibilities and so on. Now, as citizens, what is our duty? As citizens against Galamsey, what is our duty? Our duty is to call for the expeditious conclusion of the investigation and the publication of the outcome of those investigations, and ultimately, if there is evidence of wrongdoing, the trial of those persons who are alleged to have been engaged in Galamsey. Is that not the case?
Right.
We cannot say that because two persons who are members of the NDC have been alleged to be involved in Galamsey, no Galamseyer should be convicted. Hope you get the agreement.
No, you cannot say that, yes.
You cannot say that.
You cannot say that, yes.
Okay. What we can say is that they should also be prosecuted if there is evidence against them.
Yes.
And in much the same way that I am ready to defend the rights of Wontumi, and I'm ready to defend the rights of Wontumi if they establish, I also have a duty to defend the rights of all other persons, whether they are NDC, CPP, PNC, or whatever. The political party they belong to should not be an issue in this conversation. Okay? So if there's evidence, if evidence is established, if the report of the inquiry establishes that the two persons who are leading members of the NDC, vice chairman and national organizer, are engaged in Galamsey, our duty is to call for their prosecution. Their non-prosecution, indeed, cannot invalidate the prosecution of others. The judge is not a prosecutor. The judge who sat on this case is not a prosecutor. In fact, she deals with cases which are brought before her through a process. This judge cannot try the NDC persons who are alleged to have committed offenses unless they are charged and brought before her. You understand what I'm saying?
Yes.
So the fact that some NDC persons suspected of being involved in the commission of the same crime have not been sentenced should not be an indictment on the decision of the High Court judge who sat on this matter.
Fair point.
You understand? So that must also be very clear to us. Now, for those who have studied the law, and I've heard them many times, I engage with them many times and so on. One of the authorities they are quick to quote is Lord Denny. Huge figure in law and so on. And indeed, Lord Denny is quoted extensively in the judgment. And the quotations of Lord Denny actually deal directly with the weight of evidence and so on, and is quoted so extensively in this. Now, there's also another issue which was raised in the judgment and which has to do with reference to the Supreme Court for the interpretation of the Constitution to the extent that it affects this case. I'm sure you've also read the judgment, so you are aware. I'm sure Collins has read the judgment. And the judge quotes an earlier Supreme Court decision, okay, in which the Supreme Court decided that a judge may grant leave to go to the Supreme Court for interpretation where he or she has doubts about the interpretation of the law.
Yeah.
And that if he or she is convinced that the law is clear, she's not under any obligation to grant an application to go to Supreme Court for interpretation.
Yeah.
It's also one of the issues which has been raised. And the Supreme Court has a decision on that, which is very, very clear.
Yeah.
And so, now, this is where we are. There are other issues. I will leave that out for the moment.
Right.
And those issues relate to those who argue that the sentence is too harsh. You understand?
Right.
The history of this particular sentencing is interesting. One, it starts from a point where I think the maximum sentence was 2 years. And then when Alhaji Musa Husseini was Minister for Lands and Natural Resources, so they initiated moves and increased the maximum sentence to 5 years and
Yes.
so on. Eventually, my good friend Gloria Akufu, who was the Attorney General at a point, also decided that the punishment was too lenient, the sentence, and went to Parliament to seek an amendment which would increase the threshold to 15 years. The majority in Parliament then argued that 15 years was too lenient and that it should be extended to 25 years maximum and 15 years minimum. Okay. And of course, it passed. Now, in the course of the discussion, a Deputy Speaker of Parliament, a member of Parliament on the majority side then, actually made the point that they are wasting time, that Galamsey is so serious that the policy we should adopt is a policy to shoot and kill. The evidence is there. So those who said that even 25 years was too lenient and that we should shoot and kill, today are saying that the 20-year sentence is too harsh. I cannot believe it. They said 25 years is too small. In any case, this also means that the judge could have imposed a 25-year sentence if, in her view, the case merited 25 years. The least sentence she could have imposed is 15 years. That is what the law binds her to do. You understand? Now, what is interesting is that there were 2 counts on which he was found guilty. The judge decided that the sentences should run concurrently, and that is why he's going to serve 20 years. If the judge had not made a determination that the sentences should run concurrently, he could be serving 50 years. And the judge could have made that decision. He could have served 50 years. So the judge, in her wisdom, and I'm sure with some compassion, decided that instead of 50 years, he should serve 20 years. Now, Collins has made the point that 20 years is a long time. He's now how old? And that he'll come up when he's 70 and so on. The reckoning is not that way.
Yes.
The prison year is not 12 months.
It's actually 9, isn't it?
It's 9 months.
It's 9 months.
So
Yeah.
if you do the calculation, he's not going to stay in prison for 20 years.
Maybe 15
Or maybe even less.
or less. Yeah.
But in addition to that, every year, there's been no year in which the president has not granted some pardon to prisoners and so on.
Parole, yes.
Parole and all kinds of things. And that substantially reduces the sentencing and so on. Now, that is not to say that prison is a comfortable place. Prison is a horrifying place.
Yeah.
I mean, if you talk to people, I haven't been to the worst prisons. I have friends who served in the worst prisons, like Kukubaku and Haruna Atta and so on. They were in the worst prisons. But I've been to Akuse prison. I've been to Oshaford. I've been to Navrongo prison as an inmate. I've been to Tamale prison as an inmate and so on. Okay?
Because you suffered, though.
No, that's not the point I'm making.
Yeah, no, but I'm just...
So, Prison is not a place you would wish for anybody. Ghanaian prisons are terrible places to have people, you know. Even in Southern prison, which in our days we regarded as a hotel, as a 5-star hotel, even there, the conditions are horrifying.
Yeah.
So, whether he stays there for 6 months, 1 year, 10 years, or so on, it's a harrowing experience to be in prison.
Yeah.
And even if he's your enemy, you should worry that somebody like him is going to spend time in prison. But the fact is that he's not going to spend 20 years in prison.
Yeah.
You understand? Even as the situation is horrifying and so on.
Just be factual about it.
Yeah. Now, my wish, my hope, is that the appeal will be filed. And that the 3 judges who will sit on the appeal will be compassionate. They will take into account the merits, the legal merits of the case, and also take into account our nature as humans and so on, and make a determination which, as Lord Denning insists, must serve the interest of society. That's all.
Okay. Well, okay. Please come in. So when you're done, I can bring in our viewers.
Yes. So I've listened to Kwesi attentively, and I like his end part about the compassion, which is something that we all wish for Chairman Wontumi for the appeal. But Kwesi then talked about my assertion about political persecution and selective justice. Well, I insist on that what is happening is selective.
Dedi kama mamena PENDREAM TV ase. Now so far so good. Say open online portal e wo Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.